Welcome to our fresh episode of Legal Wrangle on Corporate Laws. Today, we are going to highlight two important decisions from the world of companies and intellectual property laws. Let us begin with the recent and very talked about judgment of the Supreme Court in case of McDowell Company Ltd, where the issue was whether amalgamation necessarily leads to complete destruction of corporate personality of the company, and when the amalgamated company had availed the benefit of setting off accumulated losses of the amalgamating company under Section 72A of the Income Tax Act. The waiver of interest on loans taken from financial institutions is to be treated as taxable income under Section 41 of the Income Tax Act or not. The term amalgamation is not defined under Companies Act 1956, but as understood, it means combination of two or more independent business corporations into a single enterprise. Amalgamating company means the company which is merging, and amalgamated company means the company which is formed after merger. In case of amalgamation under Income Tax Act 1961, certain benefits are given. One of such benefit is granted in terms of Section 72A, which is given to amalgamated company for amalgamation with a sick company to take advantage of carry forward of accumulated losses and unabsorbed depreciation of amalgamating company on fulfillment of certain conditions.
Hindustan Polymers Limited was a sick company which decided to get amalgamated in McDowell Company Ltd. High Court of Bombay and Madras both approved the scheme of amalgamation. The effective date of amalgamation was 1st April 1977. Hindustan Polymers owed a lot of money to banks and financial institutions. In its books of accounts, the interest which had accrued on the loans given by such financial companies was shown as the money payable on account of interest to the said banking companies and was reflected as expenditure on that count. As the interest payable was treated as expenditure, benefit thereof was taken in the assessment orders made. McDowell Company Ltd applied for and was granted the benefit of Section 72A of the Act. Under the scheme of amalgamation, the banks which had advanced loans to Hindustan Polymers agreed to waive off the interest which had accrued prior to 1st April 1977. The interest was claimed as expenditure by Hindustan Polymers in its returns. On the waiver of this interest, it became income in terms of Section 41, subsection 1 of the Act. In the return filed by the McDowell Company for assessment year 1983-84, it claimed set-off of accumulated losses which it had taken over from Hindustan Polymers. This was allowed. However, later on, it came to the notice of the assessing officer that while allowing the aforesaid benefit to the McDowell Company, the income which had accrued under Section 41, subsection 1 of the Act had not been set off against the accumulated losses. It was decided to reopen the assessment and interest amount was treated as income and same was adjusted from the accumulated losses. This reassessment was challenged by McDowell Company by filing appeal before the Commissioner of Income Tax Appeals, which was dismissed. However, in further appeal before the tribunal, McDowell Company succeeded. Feeling aggrieved, the Revenue sought reference under Section 256 of the Act and the question of law was decided in favor of Revenue. McDowell Company filed appeal before the Supreme Court.
The Supreme Court gave an interesting decision in favor of the Revenue by distinguishing the earlier judgment in the case of Saraswati Industrial Syndicate dated September 4, 1990.
The true effect and character of the amalgamation largely depends on the terms of the scheme of arrangement. But there cannot be any doubt that when two companies amalgamate and merge into one, the transferor company loses its identity with effect from the date the amalgamation is made effective. McDowell Company took over the sick company Hindustan Polymers through the scheme of amalgamation sanctioned in 1982 with effect from 1st April 1977, and that the Hindustan Polymers ceased to have any identity from that date. Since the benefit of interest had accrued after the company has ceased to exist, it was in fact availed of by the McDowell Company. What is more important is that when McDowell Company was allowed to set off the amalgamated losses under Section 72A of the Income Tax Act, then while computing those losses, the income of interest which accrued to it had to be adjusted, and only thereafter net losses could have been allowed to be set off.
So, in a nutshell, the Supreme Court was of the view that when losses suffered by the amalgamating company are deemed to be treated as losses of the amalgamated company, McDowell Company, then it cannot be said that while calculating these accumulated losses of the income accrued under Section 41 of the Act at the hands of Hindustan Polymers would not be accounted for. That had to be necessarily adjusted in the order to see what the actual accumulated losses were. Now let's move on to our second case, which pertains to the Trademark Act. The company involved here is pharma giant Cipla. The key issue was whether using a registered trademark as a corporate or trade name or style in respect of goods dissimilar to the ones for which the trademark is registered amounts to infringement, and whether subsections 4 and 5 of the Section 29, which deals with infringement of trademarks, operate in the separate and mutually exclusive spheres. Section 29 defines various types of infringement of trademarks. Subsection 4 provides that a registered trademark is infringed by a person who, not being a registered proprietor or a person using by the way of permitted use, is using in course of trade a mark which is identical with or similar to registered trademark and is used in relation to goods or services which are not similar to those for which the trademark is registered. Thus, the provision is attracted when a mark which is identical with or similar to registered trademark is used in the course of trade in relation to goods or services which are not similar to those for which the trademark is registered. Whereas, subsection 5 provides that a registered trademark is infringed by a person if he uses such registered trademark as his trade name or part of his trade name or name of his business concern or part of the name of his business concern. Now let's understand the factual matrix.
The plaintiff, Cipla Ltd, has been a manufacturer of pharmaceutical products under the registered mark Cipla. It has also been a part of its corporate name. Cipla Ltd filed a suit alleging that the Cipla Industries Pvt Ltd and others had used the mark as part of their corporate or trade name in a slightly different form in respect of household articles such as soap dishes, photo frames, etc. The Cipla Industries has a registration of a very similar mark, Cipla Plast, in their favor in Class 21. According to the single judge, the view taken in the decision of the division bench in the case of Raymond was that Section 29 operates in mutually exclusive fields, and therefore the Cipla Industries could legitimately use Cipla Ltd mark without running the risk of infringement, provided the defendant dealt in dissimilar goods. But it was the plea of Cipla Ltd that phrase use of a mark means use of a mark as a mark, and it did not include the use of a mark as a trade name. It was submitted that a registered trademark has been infringed by a person if he uses such trademark as his trade name or part of his trade name. The case was referred to larger bench.
The larger bench of Bombay High Court gave a landmark and very important decision that the provisions of Section 29(4) and 29(5) operate in separate and mutually exclusive spheres. And if a party uses registered trademark only as a corporate name or trading name or style in respect of dissimilar goods, the owner of the registered trademark cannot have a remedy of injunction. Let's understand the reasoning behind this decision.
As per subsection 1 of Section 28, exclusive right is conferred on a registered proprietor of the trademark to use the trademark in relation to the goods or services in respect of which trademark is registered, and to obtain relief in respect of the infringement of the trademark in the manner provided by the Trademarks Act. The right is subject to other provisions of the Trademarks Act. Subsection 4 of Section 29 uses the words in the course of trade and in relation to goods or services, which are absent in subsection 5. The subsection 5 uses the words if he uses such registered trademark as his trade name or part of his trade name or name of his business concern or part of the name of his business concern. These words are conspicuously absent in subsection 4. The difference in the phraseology and language used in the two subsections makes it clear that subsection 4 applies in trademark versus mark situation. It applies when the mark is used in the course of trade in relation to goods and services. Subsection 5 applies to a trademark versus trade, corporate or business name situation. It is a special provision which is different from subsection 1, 2 and 4. Thus, subsection 4 and 5 apply to different situations arising out of use of a mark. Subsection 5 does not make subsection 4 OTOs. The fact that the definition of the word mark includes name is of no consequence while interpreting subsections 4 and 5. If we hold that subsection 4 will apply to those cases where the first condition of subsection 5 is satisfied but second one is not satisfied, the requirement specifically incorporated in subsection 4 of the mark being used in relation to goods and services will become redundant. A statute cannot be interpreted in such a manner. The use of a trademark as a part of corporate business or trade name cannot be read into subsection 4. The language used by both the subsections is plain and clear. There is no ambiguity.
The High Court held that possible inconvenience or prejudice to a class or classes of proprietors of registered trademark is no ground to treat something in subsection 4 which is not there and give a meaning which is contrary to the plain meaning. With this, we wrap up this episode of Legal Wrangle. Keep watching TIOL Tube. Thank you for watching.